This is Barry Zalma on Insurance. I am an attorney who is retired from the practice of law and now spend my time as an insurance claims consultant and expert witness, an author and producer of these videos. Today I'd like to speak about how to become a professional liability claims adjuster and what is important with regard to the investigation of the third-party liability claim. The investigation of a liability insurance claim is conducted to fulfill the promise made by the insurer to defend and indemnify the insured in the event of a contingent or unexpected loss resulting in the injury to person or property as a result of the actions of the insured. To fulfill the promises made by the policy, insurers must establish a professional group of insurance adjusters who are competent investigators and competent insurance claims people. The adjusters, at a bare minimum, with regard to third-party liability claims, must be capable of fulfilling at a minimum, each of the topics that follow. First, they must be able to read the policy. To understand a third-party liability policy of insurance, the adjuster must read and analyze the policy in a logical and thorough manner. When reading a liability policy of insurance, the adjuster must understand that the facts of each individual claim clarify and color the interpretation of the policy contract and bring different nuances to the policy wording. The adjuster must know what coverage is available to the insured, the limits of liability, the territorial limitations, and the exclusions, conditions, and endorsements attached to the basic form contracts of insurance. Second, the adjuster must establish coverage. Before even beginning to investigate a claim, the adjuster must first establish or confirm coverage. To do this, he or she must get a complete copy of the insurance policy or a digital version of the policy. The company's paper copy, called the daily, and those paper-based insurers that still exist, is available from the underwriting department. For those insurers who now record everything electronically, the full policy is available in the insurer's intranet. Whether paper or digital, the adjuster must determine that the person reporting the claim is an insured of the insurer. When I was a young insurance adjuster back in the 1960s, my insurer was Fireman's Fund Insurance Company. There was also at the same time a company called Fireman's Insurance Company of Newark. Occasionally, we would receive claims from the wrong insurance company, and that could cause confusion and difficulty for the insured. Usually, we would handle the claim until we found out what was wrong and then pass it over to the correct insurance company. This kind of confusion can be avoided by simply checking the insurance company's intranet. The policy had to be determined to be in effect when the injury occurred. The adjuster should determine that the policy was in effect when the claim was made, if the policy is a claims made or a claims made and reported policy. The adjuster should determine the declarations page exists and review it to determine the basic coverage is available, the dates the policy was in effect, and the limits of liability of the policy. Then the adjuster should review the standard forms of liability insurance coverage that are listed in the declarations page and make sure that the adjuster has read and understood those standard forms. Next, if only a paper copy of the declarations page is available, the full policy can be recreated from the standard forms listed on the declarations page available from the underwriting department or the insurer's intranet. Before computers, I personally have collected over 17 linear feet of policy forms, and they still remain in my library, including insurance for equine liability and mortician's liability, as well as the regular and common commercial or comprehensive general liability policies. If none are available to the adjuster can always obtain the copy maintained by the insurance agent or the insured. The adjuster must also determine the policy limitations and determine the perils insured against. For example, if the policy is a homeowner's policy, a commercial general liability policy, an auto liability policy, or a comprehensive general liability policy, an errors or omissions policy, a business owner's policy, or some other variety of liability insurance policy, each must be reviewed and determined that they were in effect at the time of the loss or claim. Each policy will have an insuring agreement where the risks accepted by the insurer are listed, and the adjuster finally reviews whether there exist added endorsements that increase, decrease, or modify the coverages provided by the standard policy wordings. The adjuster must be familiar with each of the liability policy wordings, including the exclusions or exceptions from coverage. The so-called concurrent cause doctrine can modify how liability is determined when there are multiple causes that join to injure the claimant. In such a situation, the concurrent cause doctrine holds that if more than one cause occurs, with others to bring about a loss, and one cause is excluded and the other is not excluded, coverage will apply regardless of the proportion with which the non-excluded cause was related to the loss. The thorough investigation conducted by the liability claims adjuster must determine all causes that join to injure the claimant or the claimant's property. Each cause must be evaluated in light of the facts developed during the investigation to determine if one of the causes is covered by the policy wording and not excluded. If multiple potential causes are discovered, analysis is required, and if some causes are excluded, to determine which cause of loss is the predominant or moving cause of loss. The adjuster must establish that the person making a claim is named as an insured or is an insured as a result of the wording of the policy. Third, the adjuster must read the loss notice, because the loss notice is one of the most important documents the adjuster will see. It is the starting point of all claims because it tells the adjuster the name of the insured's address, telephone number, and email address, the name, address, and telephone number of the claimant, the date the accident occurred, the location of the accident, the basic facts of the accident, and the identity of witnesses. Fourth, the adjuster must meet with the insured and witnesses. Once the adjuster has completed this basic preparation by confirming coverage, reading the policy, and reviewing the loss notice, he or she should arrange to meet with the insured and witnesses, unless he or she is only a telephone adjuster, and then the adjuster should make contact by telephone with the witnesses and the insured and the claimant. The adjuster should explain to the insured the policy requires the insured to cooperate and assist the insurer in completing a thorough investigation of the claim being made against the insured. The explanation should include that the insurer, in order to provide the best service possible, is the adjuster who acts in good faith on behalf of the insurer. The insurer hired the adjuster to help the insured protect himself or herself from claims by the third party claiming injuries. The adjuster must also explain that he or she cannot provide the defense alone. The adjuster needs the assistance of the insured and is present to help the insured obtain the defense needed. To act in good faith, the adjuster must not do or fail to do anything that will deprive the insured of the benefits of the policy of insurance. To begin the investigation, the adjuster should obtain a recorded statement from the insured. And to make a complete recorded statement, the adjuster must get answers to the 6 important questions of all: who, what, where, why, when, and how about the claim. Each of the famous 6 questions must be answered with regard to both the policy and the loss. Recorded statements of neighbors, relatives of the insured, independent witnesses, and people who may have seen the loss-causing incident may also be useful in obtaining a complete picture of the loss. The adjuster should also work to develop witnesses not known to the insured. Witnesses can be discovered by visiting the scene of the accident, talking to business local to the accident scene, seeking security videos, and independent people who may have observed the incident. 5th, obtain a report from governmental authorities. 6, obtain relevant documents like leases, contracts, other insurance available. 7, establish the amount of the loss and claim, and for property damage claims, determine the scope of loss. But the adjuster must never take a quick look around and ask the claimant to fill out a property loss form at his convenience. Leave the claimant with blank forms except for supplemental items learned of after the initial scope was completed. Take a partial scope and attempt to do the rest later, or rely on a contractor hired by the claimant to establish the scope of property loss. The adjuster must advise the claimant that the adjuster will be retaining experts in the valuation and repair of the type of property that is involved, and these experts will bid on the repair and replacement from the agreed scope. 7th, for bodily injury claims, the adjuster must determine the extent of the injuries and treatment. And this can be determined by obtaining the identity, address, telephone, and specialty of each health claim professional the claimant retained to treat his claimed injuries, an authorization to copy medical treatment records from the claimant's healthcare provider, retaining the services of a records copying service to copy all of the medical records, reviewing the records thoroughly, and analysis must be completed that the treatment is in relation to the injury-causing event. The adjuster should consider in that regard retaining the services of an independent medical examiner to review the records and advise the adjuster whether the treatment is related to the injuries claimed and the injury-causing events established by his investigation. And if the records are handwritten, consider retaining a nurse to read and describe understandable English from the notes written by a healthcare provider. And finally, photograph the scene. Contact and speak with the authorities determine values, and fulfill everything necessary to complete a thorough investigation. This video was adapted from my book, The Compact Book of Adjusting Liability Insurance Claims, 2nd edition, which is available as both a Kindle book and a paperback from Amazon.com. If you found this video to be of interest or useful to you, please forward it to your colleagues. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so you can learn about future blog postings and future videos. Thank you for your attention.